My lady, before I address, which I will in just a moment, the second ground, which is really the crux of the matter, can I just hand up one last thing? The reason I'm doing this is because when your lordships look, as you may, at Mr. Justice Cokeram's decision, you might have noticed that he referred in the context of the grant of bail to another statute, namely the Indictable Offences Preliminary Inquiry Act. The reference in the judgment is at volume 2, page 1164. You'll see at the bottom of the opposite page, 1163, in paragraph 83, he sets out some submissions made by counsel for the Chief Magistrate. And then at the top of 1164, fourth line, there can therefore be no legitimate complaint against the Chief Magistrate's warrant. These are submissions. As there was no suitable community residence, and there is a statutory command to commit the persons who are detained to bail to prison pursuant to section 29(1) of the Indictable Offences Act. So just to give you that, I hope you've now got it. It's an act from 1917. It's been substantially amended over the years, but section 29(1) deals with the position of an accused person who is not released pending a preliminary inquiry, and provides an accused person who is not released on bail shall be committed safe custody to prison, or as the case may require. We've also, just for completeness, included section 28, which you should have on the preceding page, inasmuch as section 28(3) deals with the position where a preliminary inquiry is for any cause adjourned. Now, I'm not suggesting that was this case because it hadn't started, but that provision says the magistrate may, upon any such adjournment and subject to section 5 of the Bail Act, remand the accused person in custody by committing him to prison or such other safe custody as the magistrate thinks fit. My lady, as I say, that was really because they were referred to by Coker and Jay, and you might have wondered what that was all about. My lady, with that, I come to the second ground. The appellant complains that the Court of Appeal erred, by holding, A, that any question of release must await a final determination of the question whether the appellant's constitutional rights had been breached, and B, that the law of the land is that persons charged with murder are not to be given bail. And in due course, we'll have another look at paragraphs 72 and I think 73 of the judgment, to which my Lord Hodge referred. But can I just make one preliminary observation? And it's an obvious but rather critical one in our submission, and that is that this is an appeal from an appeal against an interlocutory order, and it concerns interim, not final relief. And at that interlocutory stage, as I've already shown you, there were serious issues to be tried. And we looked at Coker and Jay's judgment. But those issues involved, among other things, how to resolve not a contradiction between, on the one hand, the Bail Act and Section 54, but the friction that existed between, on the one hand, the prohibition against the grant of bail contained in the Bail Act, and the apparent unavailability of a suitable community residence as envisaged by Section 54. The short point, my lady, being that the appellant, at an interlocutory stage, was asking the court to order her release to the custody, care of her mother, contrary to a clear prohibition against the grant of bail. And as I'll come to, was doing so in circumstances in which she was not and is not challenging the Bail Act. And indeed, it could be said also inviting the court to order her release contrary to section 54, which is plain as to where she should be remanded. Now, my lady, as to the friction that there is between, or was between, the Bail Act and the apparent unavailability of a suitable community residence, can I just make the following points? First of all, in relation to the Bail Act, that act is concerned with the question whether and in what circumstances bail can be granted. And in the case of murder, prohibits absolutely the grant of bail, with the obvious consequence, forgive me, that anyone charged with murder must be remanded in custody. That being, on any view, any reading of the Act, the clear intention of Parliament. And therefore, any court ordering release on bail, and one might readily consider what was asked for, release to the custody of the mother, to be analogous to release on bail subject to a condition of residence and supervision by the mother. It was still, in my submission, the equivalent of release on bail. Anyone asking...
Well, rather less than release on bail, in that there'd be no reconnaissances.
Well, that is also
none of the
true.
Bail Act provisions about what happens if it's not, if it's broken.
That is also true, my lady,
Yeah.
yes. Yes, and I confess hadn't occurred to me. Yes. So anyone asking the court to do that would be asking the court to act in disregard of the clearest statutory provision. That's the point in relation to the Bail Act, which, as I say, concerns the question whether and in what circumstances bail can be granted. Now, on Section 54 of the Children Act, on the other hand, addresses a different question in my submission. It addresses the remand or committal, those are the words for trial, of a child who is not released on bail. So it's not concerned with the question whether you can grant bail. It is concerned with the place of detention or the mode of detention of someone denied bail. So in short, it concerns how someone denied bail is to be detained. The consequence that flows from recognising the different purposes served by the statutory provisions is, in my submission, that self-evidently the unavailability, as was the case, of a suitable community residence following proclamation of Section 54 could not and did not abrogate the prohibition against the grant of bail. So the Court of Appeal was in a particularly difficult position. Now, a certain amount of my learned friend's submissions have been directed to authorities that concern a slightly different question with respect. So he cited the RJR, the Canadian case. He's mentioned the Congo, and the Congo is perhaps more notable in this context for the fact that it cites and sets out much of what Lord Gough said in Factortame, which he set out in his printed case. But those cases, and others like them, concerned a challenge to the legality of provisions. So in the RJR case, the regulations that you were shown. And as I've already indicated, in this case, there's no challenge to any law, and in particular, none to the Bail Act. What the appellant was not seeking to restrain the plain effect of the Bail Act in relation to her. She wasn't challenging it in any way. Rather, she was arguing that she should be released in the face of it. And that's a very different situation to the situation in the other cases where there was a case raised as to the legality of the very provisions. And it was in those circumstances that the court was being asked to restrain the state from enforcing compliance. Now, bearing in mind the prohibition against the grant of bail and the wholly exceptional relief sought by the appellant, as I would respectfully categorise it, as well as the serious and complex issues of fact and law that remain to be tried, before it could even be determined that there was a breach of the Constitution or there was illegality in the warrant issued by the magistrate. In the light of all that, it's our respectful submission that the Court of Appeal was plainly right to go no further than it did. And I will come to the Court of Appeal's reasoning, my lord. But before I do that, can I just say a word briefly about Section 14 of the Constitution? I entirely accept that Section 14 may inform the Court's consideration of what, if any, interim relief to grant at an interlocutory stage where there is an allegation of a breach of the Constitution. That, of course, is right. But by its terms, it's important not to lose sight of this, by its terms, it is concerned first and foremost with and empowers the court to make final orders for redress. That's the word used. Redress if constitutional breaches are made out for the expressed purpose of enforcing or securing the enforcement of the human rights provisions of the Constitution. And as I've already laboured, there were very real issues as to whether there was any breach at all. Now, I said I'd come to the judgment of the Court of Appeal. Can I just invite you to turn up? Actually, would your Lordship just forgive me one moment? Before I do that, can I just return to something I was saying earlier about custody in the context of a child, and I suggested rather tritely that it could obviously envisage protective care or guardianship in the family context, or alternatively in the criminal justice context, detention or imprisonment. Release into the custody of the appellant's mother, as I've already indicated in our submission, was plainly the former. Both the judge and the Court of Appeal considered that such release was not an option. Can I just show you what the judge said? It's at page 479 of the bundle. Starts at paragraph 39 on page 478, in fact. Consequently, and bearing in mind the nature of the order which is being sought, the court will not exercise its judicial discretion, and lest anyone forget, it is a discretion that's being exercised in this circumstance, to grant a conservatory order, the terms of which would mandate the state to release the child. In any event, any attempts to mandate the state to give an undertaking forthwith to release the applicant to the custody of her mother is not acceptable in law, as to do so would put this court in breach of the provisions of the law mentioned above, i.e. the Bail Act and the Children Act itself. Now, turning to the Court of Appeal, and it's the paragraphs, among others, that we've already looked at, so page 679, paragraph 72, may I accept, in response to the point raised by my Lord Hodge, that the words would be to predetermine the final outcome of this matter was to put it too high. But submit first that it was clear that the court had very much in mind the Bail Act, and one sees that from the reference to it, the law of the land, in the following paragraph. If one then turns back in the judgment.
Well, in the first sentence of 72, you say that's perfectly legitimate, standing that there was a contention that the current place of custody met the requirement of what's now called a rehabilitation centre, I think.
Yes.
And the second sentence, you say the only criticism is predetermined is too strong.
It doesn't follow from the first sentence that it predetermined. No,
Yes.
I do accept that
Yes.
entirely. What essentially I'm submitting, and I hope I can make this good in a moment, is that the Court of Appeal had in mind, and well in mind, among other things, first of all, that there were unresolved constitutional issues and other issues.
Yes.
And secondly, that there was a mandatory prohibition on the grant of bail.
Yeah.
Now, if my lady, my lords, turn back to page 676, paragraph 62 and 63, one sees, looking at the second sentence of 62, however, while the best interests of the minor is a primary consideration, it can be outweighed by the cumulative effect of other considerations. Noteworthy is that the best interests principle is a primary consideration, and therefore there can be more than one primary consideration depending on particular circumstances of the case. Thus, there is no limit on the range of competing interests that may be taken into account and held in the balance and weighed against the best interests of the minor in the evaluative exercise that is required in matters concerning minors. And then paragraph 63, in this case, as we shall see, this court was of the view that the interim relief sought by the appellant was not the appropriate interim relief to be granted when one balances the best interests of the minor against the competing interests that are in play in this matter. That really was the balance that they were considering, and it was that informed the court's conclusion as to the order that it made.
The interim relief being sought, which they're balancing there, is released to the mother.
It is, as my lady, well, that's certainly my understanding, and my reason for saying that is that I showed you page 653, paragraphs 4 and 5, which made that abundantly clear.
Of course, they could have said, in these circumstances, it's not appropriate to do anything,
They could have said that, yes.
but they didn't.
What they did was to fashion a pragmatic and helpful interim solution. That was my my lady, without wishing to labour it too much, the Bail Act prohibition against the grant of bail to a person charged with murder clearly envisages that the person will be detained in custody, whereas the appellant was seeking release into, they use the word custody, but they mean care, of her mother. And that, as my lady's just put to me, was the balance that was being considered. Now, there's just one other thing that I would show you in this respect, just to demonstrate, if nothing else, that the question of what to do was given the most careful consideration by the Court of Appeal. If you turn to page 618 of the argument, at line 29, Justice of Appeal Barreau floated as a possibility house arrest. So we decide, look, let's put her under house arrest so she stays home with her mother. Do we have the power to do that, like a house arrest type situation? And counsel for the state replied, no, my lord, because that offends the Bail Act, it offends the Community Residence Act. Justice of Appeal Jamadar said, I mean, how does it offend the Bail Act? The person is not on bail. And the answer was, my lord, you cannot be incarcerated in your home. That is not the law of Trinidad and Tobago. So the only place you could be incarcerated is in a prison. Well, under the law of Trinidad and Tobago, yes. I suppose it could be a police station. The only other thing I would add is that you will recall that the Indictable Offences Preliminary Inquiry Act referred to custody in a prison, or as the case may be, and Mr. Justice Cokeram alluded to the detention of the brother, page 1164, after referring to section 29. The YTC, Youth Training Centre, is recognised as a place young people are sent so no doubt there are other places too, but the Court of Appeal considered alternatives. Now, can I...
If you're moving on from the order that was made, can you just help us as to what the Court of Appeal meant by requiring the Attorney General to provide a suitable community residence as provided for in the Trojan Act and the Community Residences Act? Were they requiring a licensed community residence, or were they requiring a de facto suitable community residence?
I would tentatively, but I would respectfully submit the latter, because licensing is certainly a requirement of the Act, but there was a period of grace given for the purposes of applying for a license, and it did not affect the status of the institution as a community residence. Obviously, it was a valuable and important exercise, but I would tentatively suggest that they were suggesting, or they were stipulating, a de facto community residence.
Because you couldn't have the licensing procedure completed
Exactly.
within
Exactly.
26 days.
Exactly.
Is that right?
Well, 26 days is right. Whether you could have it completed in that period, as a matter of common sense, I would respectfully suggest that my Lord might be
Very
right.
well. Thank you.
But, my Lord, what I would add to that, and it was a point that I was going to make in any event, was that may explain why, on my instructions, what happened was that the Children Authority accepted that it was a suitable place rather than granting a license or any such thing.
Thank you.
Now, can I then address the third ground, which relates to the suggestion that the Court of Appeal misapplied the best interests consideration? I can deal with this very briefly because it really follows from what I've been saying. As to the appellant's suggestion that the Court of Appeal should have considered, and I understand this to be the suggestion, should have considered whether the appellant's best interests were served by release or remaining in prison, those being the two things that in the appellant's submission should have been considered, my respectful submission, following from what I've already submitted, is that release was not an option at the interlocutory stage, and thus the question was what was in the best interest of the child in the particular unique and quite difficult circumstances of the case. And that's what I hope I've already shown you the Court of Appeal was considering. Can I now make a very short submission to which there's already been referenced by my Lord Wilson, and that relates to the appellant's home circumstances. You've already been shown, so I won't take you back to it, page 401, which was the excerpt from the affidavit filed in the brother's claim, paragraph 16D, I think it was, which set out a number of concerns in relation to the suitability of the home.
Was that affidavit put in on behalf of this appellant?
I can't answer that.
Isn't it an exhibit to an affidavit from the appellant's attorney, Mr. Stevens?
I think it is, my lord. Yes, I think it is.
Isn't it exhibit 4
Yes.
to Ms. Debbie Dean's affidavit on behalf of the appellant?
Yes.
So this evidence goes in on the appellant's behalf. What's the answer to it?
To that evidence,
Yes.
well, the answer to that evidence would have been in the brother's case, which was not this case. It was, I mean, the purpose for which it was put in this case, I'm not entirely sure. But it wouldn't have been answered in toto, at any rate, in this case, and I'm not sure it was answered at all in this case.
I see. Very well.
What I can do is additionally, although it's not an answer to the question you've just put to me, is take you to page 631 of the transcript of the argument, just to give you the full picture in relation to how this was relied upon, at line 42, Mrs. Peake, for the State, said, "My Lord, I don't know whether I need to refer you. You may have looked at it. My Lord Jamadar was talking about the home. There is an affidavit before you in relation to the brother, in which the Children's Authority visited the residence and so on, and they talked about how unsatisfactory it is for a child to be relieved. I think that should be released." There's then a bit of confusion. Justice Appeal Jamadar says that is St Michael's. Justice Appeal Barrow says the parents' residence. Justice Appeal Mundonka says St Michael's. Jamadar, St Jude's. And then Mrs. Peake says, no, the home of the child. Oh, yes, Mrs. Peake, where the child lives. And so they rejected that as a possibility because of the difficulties there and would be putting the child back into the environment. Now, the only reason I take you to that is to make good the proposition that that material was also referred to the Court of Appeal in argument. It wasn't just in the bundle. I entirely accept that it was not referred to in the judgment or fastened upon by the Court of Appeal. All I would submit, in the alternative to everything I've said, is that even if, Your Lordships, my lady and Your Lordships, were to find fault with the Court of Appeal's approach, the Court of Appeal, in my respectful submission, would have been bound to reach the decision it did, at best, from the appellant's perspective, at the interlocutory stage, in light of that evidence regarding her home circumstances. The fourth ground, I think we've essentially dealt with already. It's the complaint that the Court of Appeal failed to accord any practical utility to the vindication of the constitutional rights, or made an order which there was no evidence to justify. Well, I've shown you the reference to there only being 2 girls. It's not surprising, in my respectful submission, that the Court of Appeal, faced with the situation it was, but wanting to do something to ameliorate the circumstances in which the child was then detained, made the order it did. And it wasn't necessarily asking a great deal of the state within 26 days to make some provision that would amount to a community residence or the circumstances of community residence detention. And to suggest that there was no evidence and they ought not to have done that is substantially undermined by the fact that, albeit on instructions, I am informed that the order was complied with. I've set out in paragraph 41 what was done. I accept that there may be a dispute about that, but what is absolutely clear from Mr. Justice Corcoran's judgment is that there appears to have been no complaint after the 8th of December, which can lead to only one inference in my respectful submission. Now, as to this aspect of the case, therefore, may I conclude by simply saying this, that in our respectful submission, the Court of Appeal cannot be said to have erred in all the circumstances of the case, at an interlocutory stage, faced with a uniquely problematic situation, specifically the prohibition against the grant of bail, which is absolute in the case of murder, the absence of any challenge to the Bail Act so mandating, the fact that very serious questions remained at large, and in all those circumstances, in our submission, the court's order was a pragmatic and reasonable response to the circumstances. It was aimed, above all else, at securing, as best was possible, compliance with Section 54 and Section 60 of the Children's Act within a relatively short timescale. And although I accept it's on instructions, I would add it achieved that aim. Now, my lady, that in fact, subject to Bansraj and jurisdiction to grant mandatory orders in such cases.
Well, you haven't appealed.
No, we haven't. But, and I'm not going to be making submissions to the effect that the Court of Appeal was wrong or anything of that sort.
You're not, no.
I reserved my position in the case because my instructions were not at that stage clear. I'm not. But if I can assist the court in relation to that, I will gladly attempt to do so. I was going to just say one thing about durity. Durity, which we have copies of if you want us to provide them. My lady obviously...
Well, I went and read it over the short
Well, I'm
adjournment.
grateful. As your ladyship will therefore recall, it concerned specifically a limitation provision, a one-year limitation provision, Section 33 of the State Liability and Proceedings Act and Constitutional Proceedings. And the submission by Mr. Durity was that on a proper interpretation of Section 14 of the Constitution, the limitation period prescribed by that Act had no application to constitutional motions. The Attorney General submitted otherwise, his case being that Section 14 expressly incorporated the State Liability and Proceedings Act into the Constitution for the purpose of constitutional proceedings. That context led Lord Nichols to have a look at the State Liability and Proceedings Act and consider to what extent it was relevant in the context of constitutional proceedings. And it was in that context that he touched, and only touched, on Section 22.
That was all obiter, what he was saying about...
I entirely accept that, and I was going to say that. My lady, what he said in reviewing it is to be found for your note at page 415, letter B. This qualification on the court's powers of granting redress readily finds explanation in Section 22 of the State Liability and Proceedings Act, which limits the power of the court to grant injunctions and certain other forms of relief in proceedings against the state.
But as you say, that's obiter, induriter, and this board has ignored it many times thereafter.
Well, far be it from me to say that, my lady, but yes.
Oh, I think I can say that.
Oh, your ladyship can. I'm not sure I can. Can I just reiterate, in the hope that it may assist a little, what I've already said, essentially. As to Bansraj specifically, the Court of Appeal considered it at length. It starts the consideration at paragraph 12, and together with its consideration of Section 22, it goes on to paragraph 57. At paragraph 65 and 66, which I showed you, the court explained it and distinguished it. Whether the Court of Appeal was right in their analysis and or whether Bansraj was correctly decided would necessarily involve consideration of the ambit and scope of Section 22(2) of the State Liability and Proceedings Act and other similar provisions elsewhere. But that is not necessary in the context of this appeal, in my respectful submission. Certainly not for the purposes of determining the appeal, because first, the Court of Appeal held that interim mandatory relief was available in proceedings of the present type alleging constitutional breach, so it proceeded on that basis.
You don't suggest they were wrong to do so.
Secondly, as your ladyship pointed out, I don't appeal from that, and I'm not making that submission. I don't entirely rule out that I might not argue that in another case in the future, but I'm not in this case. Thirdly, mandatory interim relief could in any event have been granted, and indeed was granted, it was one of the two bases it was granted under the Judicial Review Act. And fourthly, it's not necessary to consider it because whatever the position, if the board accepts my submissions, it was simply not open to the Court of Appeal to grant the relief sought for the reasons that I've given. It is somewhat ahead of schedule, and I'm not inviting my learned friend to reply for 40 minutes. I've come to the end unless I can assist the board further.
It appears not. Thank you very much, Mr. Stevens. Thank you.
Thank you, my lady. Can I deal with a number of points raised in the morning, and then I'll deal with the ones this afternoon. So some of this is very straightforward. The dates of the trial, they were from the 15th to the 18th of February. I'm sorry it's taken some time to confirm it, but we felt it.
What year?
Of 2016.
Yes.
The second point I wanted to cover is the use of the word bypass. It may be a matter of the enthusiasm with which one expresses things, but the basic point that was being got at is the effect of the amendment was to transfer the approval of rehabilitation centres from the Children Authority to the executive. That's the point. Whether you call that bypass or whatever else you call it, it's a significant change because it means there's no longer an independent body issuing in respect of inherently vulnerable people. The third point I want to turn to is the approach that was taken in relation to the evidence about rehabilitation centres. As I understood the position outlined by my friend, he appeared to be contending that the problems were specific to this claimant. That, with respect, is plainly wrong. If one goes back to the evidence, which is relied on, 147 in the electronic bundle, you can see if you go to 143, first of all, I'm so sorry. 143, paragraph 2 begins by saying that there is an evaluation and report in respect of St. Jude or elsewhere with a view to finding the name and location of this community resident capable of...
Which paragraph are you referring, please?
Paragraph 2, page 1. I'm so sorry, it's
147.
I'm so sorry, it's my fault. Two different numbers. 147. It's the affidavit is filed to conduct an evaluation report in respect of St. Jude's or other facilities that may qualify as community residence with a view to providing a name and location of a suitable residence. Now, obviously, the court's concern is what the appellant's position or how the appellant's accommodation should be addressed. But the points made in this affidavit are general, and they apply to all children, not to this specific child alone. And it's important, for example, to remember that some of the point which my friend has fixed upon about the evidence in the affidavits for the brother really don't focus at all in there. What we're talking about is general statements. So, for example, if you go through this, paragraph 5 at 148 talks about there being community residences, children's homes, and rehabilitation centres. It then makes the point that the Children's Authority, this is paragraph 8, page 149, looks at or considers two possible rehabilitation centres, which is St. Michael's Schools for Boys, which is where the brother is kept, and St. Jude's School for Girls. Now, that's important to appreciate because although a large number of other accommodations are referred to as children's home, they're completely irrelevant for the purposes of accommodating someone like the appellant who's been remanded on bail. So we're actually concerned with two possibilities. And in fact, because it's a single sex, it's one. Is St. Jude's going to work or is St. Jude's not going to work? And what's said about St. Jude's, if you go to 150, it's said that paragraph 12 that the requirements are more stringent for rehabilitation centres than children's homes. That's important so far as it goes, but the appellant could never have gone to a children's home. And then we find paragraph 15, the point which Lord Kerr reminded me of about failing to comply with 15 out of 52 requirements. And what it comes to is this, is there's nothing specific or individual to the appellant, which is the problem here. It's that, for better or worse, there is no lawful place for him to be accommodated. And I'm very anxious to make that plain, because despite the very attractive way in which it was put, this is not a one-off case with respect. It's a problem which is general in character. Now, the next, I want to just touch on some of the points made in the course of the afternoon. During the course of this afternoon, when discussion of the Bail Act was raised, my lady, Lady Hale, raised the point that some of the restrictions or conditions like recognizance or much else may not be available to govern this particular situation. With respect, we would disagree, because I refer to the terms of section 14.2. It may be worthwhile turning that up, please, and that can be found, yes, it's at 926.
Okay. So that would allow the court to extract reconnaissances and punish people if they didn't live up to the promises, because presumably there'd be all sorts of promises the mother would have to make. You know, I'll produce her whenever she's required so to do. I won't let her out of my sight. All sorts of things like that. And then, obviously, all of that could be attached to bail, and it would lead to consequences if not complied with. Could all that be done under section 14.2?
And the reason why I say that
Probably, you may very well be right.
Let's look at section 14.2 for a moment, if we may. The relevant words are, such orders, issue such writs, and give such directions as it may consider appropriate. So pause there, very broad, hardly broader. For the purpose of enforcing or securing the enforcement. Securing the enforcement of any constitutional rights is a very apt phrase here, but the point.
And under section 14.2, there is jurisdiction to make orders against private persons, is there?
Well, that's a point which hasn't been taken so far.
Well, let's take it now.
But the point about it is for securing the enforcement of the provisions relating to the protection of someone.
Yes.
So, actually, this is the protection of the state by virtue of recognizance and so on. It's not.
Well, no. Well, with respect, this is a no. I don't accept.
We're into fantasy land here, aren't we?
Well, that would be one way of characterising it, but I'd at least like the opportunity to finish the submission. Thank you.
Oh, that was far too generous.
And the submission is this: I don't accept the point made by my lady, Lady Black a moment ago. It's for the protection of the state. Nor actually do I accept that it's something which an individual could be the beneficiary of. The point I'm making is that if one's here dealing with a complicated situation, and with respect to the evidence that this is very complicated, the real risk with this child being returned to the custody of the mother they're pretty thin, frankly. They're there. I'm not saying they're not there. But if they needed to be addressed, the point I would make is this, would be...
Isn't that not also Fantasyland? The mother was the mother of 2 children, both of whom were facing murder charges. I mean, it'd be a big issue to return a young girl facing a murder charge to her mother in that context.
Well...
I mean... To say this could be done easily, I think is...
I'm not saying that it can be done easily, and I'm actually saying, what I am trying to say is this: it was possible to address the individual facts and formulate conditions to see if they work. It's a question of degree. It may be impossible. It may be the mother is incorrigible. It may be all sorts of things. It may be that the circumstances in which they live make this wholly inappropriate. But to rule it out of court, in principle, is the defect of which I complain. Now, I'm not saying it's easy for a court to grapple with, but perhaps yesterday was an example, at least for me, of issues that were not always easy for a court to grapple with. But the point is that the scope of Section 14.2 is wide enough to embrace it. I think one could make a further assumption, which is of some importance, is I think it's safe to infer the mother would want the child to come back. They could give undertakings if necessary, which can be treated appropriately if necessary. And therefore, whilst I'm obviously disheartened, as one must be, to be told that submissions are in fantasy land, nevertheless, I press on to say that actually, in a case which involves really quite serious and detrimental consequences to a minor, these steps should be taken.
Yeah.
The next
Nobody's suggesting this wasn't a very serious situation.
No, I'm not.
Nobody's suggesting.
No, but so, just so that we're clear, what I'm saying is that it's capable of being addressed, and that the Court of Appeal was acted prematurely in saying, effectively, which it did, that the law of the land precluded any other alternative. I've made the point before, but it is worth remembering that the law of the land pointed in two directions. It didn't point solely in favour of the Bail Act, it pointed in favour of the Children's Act too, and of the attendant suite of children legislation. And this is a phrase which has been used again and again by my learned friend, Mr. Stevens, that this was all jolly complicated, but we haven't heard any argument addressed as to why the issues were as complicated as all that in terms of constitutional breaches. And whilst, when Mr. Stevens returned to paragraph 72 of the judgment, and the two complaints that I made of it, he accepts that predetermined might not be the best way of putting it, but I do, with respect, submit that it is an important constitutional protection that proper principles for interlocutory relief are applied. And MacDonald is a very helpful indicator because it obviously has the authority of that court, and it's a jurisdiction which is familiar with constitutional interim relief cases. And I don't mean this with any disrespect, it would appear from the approach, at least in some respects in paragraph 72, as if the Trinidad courts are less familiar with these sorts of approaches. And indeed the submissions were made on behalf of the state that the courts should simply stay their hand until the final trial. And with respect, that is wholly inappropriate in this context. In other contexts, it might be right. In this context, it's not right. So my friend managed to get through his submissions without ever addressing whether MacDonald cast any light on this at all. And that ultimately is a matter for the board, obviously. But in our submission, the MacDonald principles, or whether you call, and as I say, I refer to them just because they actually had the advantage of dealing with constitutional relief, or whether it's factor tame, or whether it's Bakongo, they all point to the same thing. Interlocutory material is designed essentially to look at what is appropriate given the balance of convenience and the public interest. That is the critical issue. And to remind you of the point made powerfully in the MacDonald judgment, which is that the status quo plays no role in that. And if this was genuinely a case that the Bail Act had ruled and what we were seeking to do was subvert it, that would be one thing. But we're not. That's not this case. This case is that the mode of detention and the place where she was to be detained was not in compliance with other domestic legislation, which is of equal constitutional status. And that has to be respected in our submission.
what can be said, Mr. Clayton, in your favour, is that Mr. Harris didn't see fit to challenge, Mr. Stevens didn't see fit to challenge the Canadian approach, probably because on his submission he didn't need to, but...
Well, I understand that, yes, but if I may say so, and I mean no disrespect at all, it's one thing to say as an advocate, I don't need to deal with this. It's quite another to advance the case as to why you don't. Speaking for myself, and this may be entirely a problem of my own, I was struggling to understand the principles which underlay what he was saying. It still remains an interim application.
Yes.
And unless, and it's dealt with in McDonald, this is all really familiar stuff, there are certain circumstances, I accept, where the interim relief principles, the American Cyanamid principles, have to bow to reality, like it's a final hearing. That is not this case. That really isn't this case. Well, I'm virtually at an end. In fact, all I would repeat is this, is that what we're told, or what the final conclusion by my friend was, is that it was a uniquely problematic situation involving complex issues. With respect, it's easier to say that than to actually demonstrate it, and the arguments about constitutional rights were not advanced here, or the answers to why there was a breach of the constitutional rights were not advanced, and therefore, in our submission, the McDonald principles ought to have some weight in the approach that the court takes. Subject to that, I apologise for overrunning.
Well, I think you've only overrun a very small amount, because I thought not at all, yes.
I'm not sure if you had your 20 minutes.
Yes. Yeah, I think you've got another 3 minutes.
3 minutes?
No, and that's, I should have asked, may I just ask if there's something I've missed? Well, thank you very much.
Thank you. Well, thank you all very much indeed. Please do not think that because we have endeavoured to conduct this hearing in a friendly spirit, we do not think that it's a very serious matter, because we do. And we're grateful to you all for all your submissions, and the board will take time to consider their judgment.